Okay, let's get right into this. So something happened in one of my hearings, and it brought forward the need to use the new emergency message EM24026. Please remember, with these emergency messages, they're kind of like executive orders, except they're from the commissioner or things that are right under the commissioner. And what's interesting about them is that they're like these huge, massive changes. And what's crazy about it is we never would really see stuff like this with the SSA until now, with these huge, big, different changes that are going on. But let me get right to it specifically. So they released this emergency message. And the message says basically that there are certain jobs that they're not going to continue to use going forward for vocational analysis, which is important because most people are found disabled through what's called a vocational allowance. It's where all of their impairments combine to essentially say that they're disabled because they can't do a full-time work. And that's like any job out of all the jobs that exist in the national economy. But what I missed, and this is super important, and it is a big rule change. So I had a hearing, and I'm just going to tell you what happened. I had a computer that broke before I went up north to New Jersey, right? You guys know I'm in New Jersey. I'm doing all kinds of stuff with tractors, yada, yada. Okay, cool. So what happened is this. Bottom line is I have a hearing. I don't have my regular computer. This new computer doesn't have the login stuff to go ahead and get into the private server where I keep my circuit court arguments. Okay, every attorney has one of those. We have like a Word doc for these types of arguments, Word doc for these types of arguments, blah, 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 blah. I usually don't have to go to it because most of them I know by citation in my head. But there was one that I needed that I couldn't remember. So I said to the judge, Your Honor, I object to the use of this job and this job. This job only has 5,000 available in the national economy. That job only has 6,000 available in the national economy. I object to their use. Judge says, okay, what's your citation? And I say, it's right, And I couldn't pull up the doc because I didn't have it on that computer. And I couldn't access the server because I didn't have the password for it on that computer. So I was in shit shape. I was like, oh no. So really quickly, I turned around and said, Your Honor, I'll go ahead and submit it directly after the hearing, right? Because I get the password, I go through it, figure it out, and give the citation. But here's the kicker. I didn't have a password because it was a very secretive one and a very special one that's like one of those giant codes. So anyways, I was thinking I can't magically figure this out on the spot. I'll ask for additional time, right? Okay, I'll say I'll go ahead and do it after the hearing. Then the judge goes, well, in order to do that, Attorney Hnot, and this particular judge has a very strong voice. And he's one of the ones that basically raised me in my geographic area. A lot of these judges, I've been working with them for over 10 years. They've raised me in the art of Harry Potter disability. You know what I mean? Like the magic, the just of it all. And so he says, well, attorney, okay, you'll have to ask for additional time post-record to keep the record open, or post-hearing to keep the record open. I said, yes, Your Honor, I'm requesting additional time to submit, yada, yada, yada. He said, well, I'll give you 3 days, Attorney Hnot. It was, it wasn't 24 hours. It was 3 days. It was very kind of the judge to do that, and I really appreciated it. Here's the bottom line. I first covered this rule, and I missed something. And I think it's important because but for that computer being broken, I would have not caught it. There's all these circuit court cases that talk about what is allowable for the amount of jobs to be available in the national economy for that job to kill your claim and kill your ability to get disability benefits. Because, right, if they can't offer that job because there's not enough of them in the national economy, they got to go ahead and pull that job and find another one. And if they run out of jobs, boom, you're closer to being found disabled. So it's super important. It's not like a little bit, it's super epic important. Here's what I found. I'm going to show you exactly where it is. Here's the press release. Okay, cool. Here's what they found. The agency has identified 114 DOT occupations with jobs that exist in very limited numbers, if at all, in each of the 9 U.S. Census divisions of the country. Just so you guys know, the census divisions, there's like 9 of them. There's like one really long one in California, and then they just go boop, 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 boop across the United States. There's 9 of them, okay? Based on this finding, the agency will not use these occupations to support a not disabled finding at the last step in the evaluation process for disability determinations. AKA, they can't use these to deny you. That's the bottom line. However, I missed something. Let me read it to you. I should have had this pre-organized. I know. Here we go. Okay. In developing this guidance, this is straight from their ruling, just so you know, if you're wondering what it is, it's that one right there. Whoop, right there. Okay. Let's go through it. In developing this guidance, we use current federal employment data from the Bureau of Labor Statistics, Occupational Employment and Wage Statistics, OEWS, program for the years 2020 to 2022, right? So 2020, 2021, and 2022. The OEWS program publishes data using the Standard Occupational Classification, SOC, system. First, we summed the OEWS state-level employment data for each year by U.S. Census Division, 2020, 2021, 2022. The census divisions divide the states into 9 geographic areas, as is explained here, which they go into this little cute thing. Then we identified the SOC occupations with fewer. Here's the important part. So if you're just tuning in right now, this is something that's going to help you get found disabled in the future. Then we identified the SOC occupations with fewer than 1,000 employees in each of the 9 U.S. Census divisions in the 2020, 2021, 2022 OEWS panels. There are 35 SOC occupations that meet these criteria. We then identified the corresponding DOT occupations using the Occupational Information Network, ONET, via the DOT, Dictionary of Occupational Titles. Using this method, we identified 114 DOT occupations, each of which corresponds to one of the 35 SOC occupations with jobs that exist in very limited numbers in each U.S. Census division. We will now consider these 114 DOT occupations isolated in all regions of the country. All right, let me just simplify for you something real quick, okay? Under 20 CFR 404.1566 and 416.966, when we make a determination, you're deciding if you're disabled, or decision, at step 5, the 5th element of disability, of the sequential evaluation process, the 5 elements of disability. So they're looking at element 5. So when they make a decision on the final element, we will not deny disability benefits based on the existence of isolated jobs which exist only in a very limited number in relatively few locations outside of the region where the individual lives. We have determined that the DOT, Dictionary of Occupational Titles, the DOT occupations listed below currently satisfy the regulation definition of isolated jobs in all regions of the country. Now, what did everybody miss? Including myself. I missed this too. What they're saying is they did the math, and we now have a de facto definition of what regulatory definition of isolated jobs is. Because before, all we had were different circuits throughout the United States with really weird numbers, right? 1,200 is enough. 1,200 isn't enough jobs available in the national economy. And they're all making these decisions as to whether or not the job can be considered that you could potentially do to get you found denied for disability benefits. So the whole thing is a numbers game. Well, is 5,000 jobs available in the national economy to be that widget maker? Is that good enough? Maybe. In some circuits it was. In some circuits it wasn't. I just read to you something that includes the actual definition, but it's not simple. You had to kind of think about it. And this case, where I had a screw-up situation where I couldn't get access to my notes, my circuit court rulings, actually gave me an answer that nobody's talking about. Here we go. What I realized from this situation, I'm going to read to you specific information about it. If we go by their removal figures, right? And they talk about it here. They said, right over here. They say, look, okay, where is it? Okay, we identified the SOC occupations with fewer than 1,000 employees in each of the 9 U.S. Census divisions in 2020, 2021, and 2022. Now think about the math here, because it's something you can easily miss. I missed it. Don't let me. I missed it until literally I had a computer problem and had to figure out a way to answer the judge. The judge wanted a brief update. I had to write a brief, and I was sitting there pouring through all the circuit rulings. This one's not helpful. That one's not helpful. And then I realized, holy shit, I had just done a video on this very thing. Listen to the language. It's important. 1,000 employees. It's got to be fewer than 1,000 employees in each of the 9 U.S. Census divisions. That equates to, next page over here, the regulatory definition of isolated jobs in all regions of the country. So what do? You do the basic math. If we go by their removal figures, if there are less than 1,000 employees for each of the 9 divisions, we can assume that 999 employees multiplied by 9, which are the 9 different divisions, equals 8,991 available jobs throughout the nation. This means that the commissioner, by and through ORDP, ODP, which is like a regulatory policy group within the SSA, but basically the commissioner. This means that the commissioner has now given us a de facto definition of how many jobs have to be available in the United States, or else you throw that job out, which means that you can object to that job being used during the vocational expert portion of your hearing to get that job killed off. Well, how many of those jobs need to be available in the national economy for it to be acceptable? It has to be one more than 8,991. So at 8,992, that job is acceptable. But at 8,991 or less, that job is not acceptable, and you have to go ahead and object to the use of that job being used against you. So when they come forward and say, well, there's this many jobs in the national economy, and it's 7,000, it's 8,000, it's 4,000, it's 5,000, you have to object, because the commissioner has now given the green light that if it's less than 1,000 employees over the 9 districts, 9 divisions that exist via the U.S. Census, that means that, very simply put, that's 8,991 available in the national economy. So what does this mean? It means that when they come out with the itty-bitty jobs, where there's 5,000, 6,000, you object. It also means that if you can limit the other jobs that exist, right, that are like 10,000, 11,000, if you can get the vocational expert to say, well, if the hypothetical individual also had this limitation, it would lower the available amount of jobs for that particular vocation down from, let's say, 11,000 to 8,000. And boom, then you've killed off the job. So let me give you an example. Okay, let's say, you had this one job and there's only 11,000, openings available for that job in this hypothetical world, right? Cool. Okay. How many would still be available for that job if the claimant was required to go ahead and use a walker with a seat, or as we all call it, a rollator? Well, it would erode the vocational base of that job so that there would only be 7,500 jobs available in the national economy. You then object and say, Your Honor, I object to the use of that particular job because it is less than the amount the commissioner, through the policy center of the SSA, has given as the basic definition of a job that is too limited in the amount of openings available in the United States, because it had less than 8,991 openings. It's technically less and total. So it could be 8,991 or less. Just absolutely mind-blowing, because I didn't see it at first. I didn't think that that would be it. And before, we were just using circuit here, circuit there, and they all had different... They were like, hey, 12,000 is not enough. Hey, 5,000 is totally enough. it was just all random crap and it was not good. But now we have an actual definitive definition that we can use to beat vocational experts as a tool to win Social Security benefits going forward. And you can use this for CDRs too when you're going through the 8-step sequential process as well, which is absolutely amazing. Deb Carter, thank you for the $5 donation. That's absolutely amazing. Very, very cool. Definitely love the people in the chat as well. That's awesome. So I hope you guys enjoyed this, because in that emergency release, they gave us a new standard and the ability to define that standard. And every single hearing, I would say in most hearings that I have, they give jobs that are under 8,991 available in the national economy. 8,991 openings where this hypothetical person could potentially find this job. So that new standard is incredible, because you're going to be seeing a lot of jobs getting kicked to the curb as a result of it, which means more people will be found disabled. All right, with that said, I will catch you all a little bit later. We do have to go live and answer questions. It is Thursday night. I'm only going to be doing about a half an hour. And then tomorrow, yes, I will be talking about the debate. I still have to let it digest a little bit. There wasn't a ton on Social Security benefits in the debate, but the bottom line is tomorrow we will work on that. Please remember to like. Please remember to subscribe. Go over to Google. Throw some stars up on the board for Disability Resolution Law Firm. I will catch you all in about 10 minutes, and we'll go from there. I'll see you soon. And you guys know how the live sessions work. Tuesday and Thursday, I go live, right? Use a fake name when you call in, 407-279-1754. And use your legal question right up front. No story mode. You get 5 to 7 minutes. I'll see you in about 10 minutes. We'll get it rolling, and we'll go from there. Thanks so much. All right. Bye-bye, everybody. Bye-bye.